Hi, I'm Jane Reardon at the Illinois Supreme Court Commission on Professionalism. Welcome to Reimagining Law. In this video series, we're exploring how legal professionals are adapting the delivery of legal services to better meet the needs of today's consumers. Today, I'm joined by two thought leaders in this space. Mary Ann Mason, retired Justice of the Illinois Appellate Court and current co-chair of the CBA CBF Task Force on the Sustainable Practice of Law and Innovation, and Zack DeMeola, who's Director of Legal Education in the Legal Profession at IAALS, the Institute for the Advancement of the American Legal System in Denver. Whew! Thank you both for joining me on this segment 2 of the attorney re-regulation reform issue.
Nice to be here. Thanks, Jane.
So last time we talked about the state of legal re-regulation around the country in general and Illinois in particular, and why attorneys should care about this issue. In this segment, we're going to get into some of the professionalism challenges that may surface when we change the rules of professional conduct that have governed attorneys' practice for decades. First, to Justice Mason, last time you explained some of the key recommendations of the CBA CBF Task Force report, and I know we're in a public comment period through August 21st. What can you tell us about comments received so far?
First of all, we recognize that change is scary, and change needs to be undertaken thoughtfully. We released the report publicly at the end of July. Today is August 5th. The report is 112 pages long with multiple attachments. And so as of today, we have received little in the way of feedback. I attribute that to the fact that the recommendations of the task force require time to understand and assimilate. And people need to form thoughtful reactions to those recommendations. So I expect that though we have received little feedback as of today, we will receive substantial feedback, both written and oral, before the public comment period closes on August 21st.
Great. Yeah, and those comments will be helpful to the court, I know. So I hope people will take the time to comment. One of the animating principles behind this recommendations about regulatory reform is it will increase people's access to legal services. In other words, it will stop or maybe even shrink this access to justice gap we have. And opponents say there's no evidence to support that proposition. Zack, is there evidence that would support the conclusion that changing these regulations would help the access to justice gap?
There is in fact. You know, to be fair, it's difficult to find evidence within the United States because a lot of the proposals that are being recommended haven't been allowed in the past. And so there's nothing really to look to here. But if we look to other countries where similar recommendations have already been implemented, we can see there's unequivocal evidence of improvement. So for instance, in England, where some of the restrictions around whether lawyers can partner with other professionals have been relaxed or even eliminated, one thing that we've seen is when lawyers do form those sorts of multidisciplinary practices, when they have more access to innovative technology in a way that lawyers here in the U.S. do not, they adopt that technology. They adopt innovative management systems. They adopt case management and client outreach in a different way. And what we know is that those sorts of efficiencies has lowered the cost for the delivery of legal services for those sorts of organizations in England. That's an unequivocal fact. In other countries too, we've seen this. In Ontario, there's more independence, for instance, for paralegals to help people with the sorts of cases that we see are most common for people in the U.S. Who show up without legal advice or legal assistance. So things like debt collection or housing and eviction issues, those paralegals are offering tiered legal services at a lower cost for people. Well, the paralegal system up there is strong. There are well over 8,000 independent paralegals serving that demand right now. But if we look here in the United States, we are starting to see some evidence that these sorts of recommendations can help. And that evidence right now is coming from Utah. Utah has opened up an application process for alternative legal services, specifically on an emergency basis to address COVID-19 pandemic problems. And what we're already seeing are applications for new legal services at a lower cost to help people in a variety of different ways. I mean, there are full service, full lawyer service options, but there are other options for some of these applications, such as just reliable legal advice that's really available, or partial help, help filling out documents and so forth. So those services exist to meet the demand, so long as they're allowed to.
Okay, Justice Mason, there's an argument that if we allow lawyers to go into business and share fees with those who are not lawyers, it will undermine professionalism and the integrity of the profession. What is your response to that?
First of all, the District of Columbia has allowed people and entities other than lawyers to have an ownership interest in a law firm for decades. As far as I know, there are thriving law firms in the District of Columbia. The argument you mentioned is a very common argument among opponents of change. I understand the argument. I've heard it often. I disagree that lawyers will be so easily co-opted into abandoning their professional responsibilities to their clients if someone other than a lawyer has an ownership interest in their firm. I don't believe that will happen. The other point is that our task force is not recommending that step, at least not now. We're recommending that the Illinois Supreme Court study the viability of allowing entities other than lawyers to have an ownership interest in a law firm. But the recommendation that we have made is simply to allow an intermediary entity that is itself not a law firm to serve as the connection between lawyers and clients. And as I've said before, once the connection is made, the lawyer serves the client as they would in any other case, and their judgment is unaffected by the fact that they paid something for the service of matching them with the client.
Gene, I'd like to add to that.
Go ahead, Zach. Yes.
Yeah, well, because it's an important point, and I hear it a lot too. From just a broader perspective here, the touchstone of our profession really is the public interest. We are, as lawyers, officers of the court. We cannot stand by while the system continues to drift away from the very people it is meant to serve. And so even just allowing for intermediary connections between clients and attorneys is an important part, I think, of preserving the profession, of preserving the high standards we have for ourselves. And I might mention, even though it's not at issue here, when lawyers do partner with other professionals, as we've seen in other countries, what happens is that they're regulated. The other professionals are regulated to the standard of the lawyer. And so the ethical practices of those organizations, of those other professionals, rise to meet the high standards of lawyers.
So one of the recommendations of the CBA CBF Task Force is that tech companies, either by themselves or in collaboration with lawyers, be allowed to deliver legal services. And if the focus is on the public interest, where are there consumer protections, Justice Mason, and where are they?
Well, as of right now, tech companies are offering these legal services and consumers are availing themselves of that fact. these tech providers are, in the present circumstance, entirely unregulated. So we have no way of knowing, for example, whether the information that consumers are getting is accurate, reliable, and whether they're overpaying perhaps for the service that they're getting. So the proposal that we've made is to bring tech companies, as Zack mentioned, under the umbrella of our profession and to regulate them so that the services they provide and the information they dispense is consistent with the standards of the profession. So the fact is it's already happening. It will continue to happen whether we change or not. And it is for the good of our profession as well as the public that we serve to regulate these entities so that the service they provide is valuable.
Zack, do you have anything to add to that?
Yeah, I think that what Justice Mason says really emphasizes the point that what we're talking about here is not deregulation in any sense. I mean, we're actually just changing the way that we regulate things. And by reframing and reimagining the framework for the delivery of legal services, we allow for more services to reach more people, but in a safe way. So I think that's an important point to make.
Yeah, and I know that investment in legal tech has gone through the roof in the last couple of years. Justice Mason, on that point, will allowing legal tech providers to deliver legal services crowd out our solo and small firm practitioners? Can they compete if we allow these legal tech providers to get bigger and bigger?
Well, if we allow lawyers to collaborate with these tech providers, then the synthesis of that collaboration inures to the benefit of lawyers and to the public we serve. If we continue to treat them as separate entities, unrelated to the legal profession, then lawyers can't realize the benefit of collaborating with those tech providers. Right now, the majority of litigants who appear in court without an attorney are not being served by solo and small firm practitioners, although I believe that a very profitable practice could be built around the one-to-many model that collaborating with tech providers allows. And so we're not taking anything away from lawyers currently practicing now. What we want to do ultimately is connect those lawyers with this vast underserved population.
Yeah. Zack, do you have anything to add to that?
No, I absolutely agree. I mean, if you look at the numbers, it's astounding. There is an enormous market that's untapped for legal services that just the need for legal services that just isn't being met. And if we can, as we say at IAALS, unlock legal regulation, we can allow lawyers to tap into that market, which is good for lawyers, but it's very, very good for the people in need. And all of that is critical to supporting the public trust and confidence in our legal system.
And can I just make one final point, Jane?
Sure.
The perception is that there's really important cases that involve big money and constitutional issues and all sorts of really high profile issues that lawyers would love to handle. And that what we're talking about are all these so-called little cases, the landlord-tenant, the consumer debt. These cases and the fact that people are not able to find a lawyer to help them on these cases have such a negative impact on society as a whole. It is renting the fabric of our society to have people have to face these life-changing cases, even though they're in high volume courtrooms, without the help of a lawyer. And as a profession, I think it's our responsibility to address that.
You bring up another point, Justice Mason, that we haven't really talked about before, but we're in a unique time with this pandemic, and looking down the pike, many are saying there's going to be just a huge influx of consumer debt, housing, eviction cases. Sounds like this is the type of case that these regulation changes are aimed at. Am I right?
If not now, when?
Yeah, yeah, it's only going to get worse.
Right.
And yet, we lawyers are trained to revere precedent, right? And we change very slowly, typically, and that's the way we were trained, etc. What do you say to lawyers who express concerns that changing the regulation of legal services will undermine the character of our legal profession? Zack, do you want to take that one on?
Yeah, I mean, I think I've said this before, but we're officers of the court. I mean, we are here to uphold the integrity of the legal system. We're a key component of that, and we need to be concerned about the public interest. That's a wide array of different variables that we need to factor into our thinking here. But it's critical, and it's critical now. I mean, what you just mentioned, Jane and Justice Mason, there ought to be some urgency around the current circumstances that we have with regard to COVID-19, of course, and the explosion I think we can expect to see for legal needs, but also the urgent issue of systemic racial injustice. A lot of these problems that we're discussing now, this lack of access to services, tend to affect minority populations disproportionately. So when I think about the character of the legal profession and the standards that we hold ourselves out to as officers of the court, my first thought is we should be leading. We should be leading the changes to address these urgent problems that the public needs to be addressed. And we are experts. We are able to do it. It may require a little bit of a cultural mind shift away from the reliance on precedent into a more visionary view of the future. But I think these changes and these recommendations and this movement do nothing if not support the high character of the profession.
Yeah, yeah. Justice Mason, do you have anything to add?
Well, 6 months ago, if you had said to me that most court hearings are going to be virtual online, I would have said, you're crazy. And look at us now. Courts are pivoting to harness the advantages of technology. Our profession needs to do the same, again, because it's for the good of our profession and the good of the people that we've taken a pledge to serve.
Right. Yeah. I mean, the changes that have been undertaken in the court system as a result of the pandemic are really impressive in a short period of time. And Zack, I just want to add on, at the Commission on Professionalism, what we often focus on is the preamble to the rules of professional conduct. And I think it's important in this arena to remember that the public interest is not just current clients, right? We aren't just protecting the clients we have, and that's the focus of most of the rules of professional conduct, but we also have a wider obligation to society at large to work for a quality of justice that affects everyone. And our profession is unique in having that responsibility for the very fabric of society. And that's why it's exciting to see so many dedicated legal professionals really putting our thinking caps on around how can we change and unlock our own regulations so we can do a better job. And the events of the pandemic and the unrest that has been unleashed following the death of George Floyd just bring this to a higher sense of urgency. So I really thank you both for joining me. I appreciate all you're doing in this area. I thank you all for watching. Please like and share this video and stay connected with us to get access to later episodes as as they drop, as they say in this business, I guess. Thanks for watching and be well.